So that's exactly what that's referring to. So those three are usually very, very easy for students to grasp and remember, as well as the reasons for statutory interpretation. So these are very easy marks on the exam and any SAC questions, and very easy to explain. Okay, now the next thing that we need to know is the factors that affect courts in lawmaking. So these include the doctrine of precedent, obviously being restricted, having to follow it, having to abide by it if it's already existing, which we already talked about. Different approaches to actually being a judge, so either the conservatist approach or the activist approach. Cost and requirement for standing. So look at each one and we'll look at the strengths and weaknesses. So obviously the strengths of the doctrine of precedent include that actual purpose of the doctrine of precedent to ensure consistency and fairness, because it ensures that all cases that have similar circumstances must be treated in the same way. It would not be fair if a person did exactly the same thing as another person, say with regards to a criminal offense, and then the consequences of that action are completely different. So one person gets let off because there's no law for that circumstance, and the judge conducted statutory interpretation and decided that that person shouldn't be punished, and that's what Parliament intended. But another person gets punished and goes to prison because the act was interpreted differently by another judge. So that's why we have the doctrine of precedent, and all future cases with similar circumstances must be treated in the same way. The same type of decision must be handed down, um, and we ensure consistency in that manner. Additionally, by looking at past cases, litigants can judge how their case is likely to be decided. So you could be a plaintiff, for instance, considering if it is worth initiating a certain civil claim against a person or a business or something like that. And you can actually obviously access those past cases and see what precedent was, and if there is an existing precedent that needs to be followed. And then that your case has similar circumstances, so you're likely to get that same beneficial decision, and you'll get those damages from the defendant, and you'll probably be successful. So it actually helps to see if pursuing a case is worthwhile, and initiating, for instance, a civil claim is worthwhile. Also, courts can develop law where Parliament has not yet created statute. So all those gaps in statutory law and in acts can be filled in by courts because they're doing statutory interpretation, and because they're developing common law and new precedents and new principles. Now, some of the weaknesses, so it can be inefficient because in order to change the law and keep it updated, the litigants must bring a case before the court. So there is the requirement for standing. Only someone that is directly affected by a law can initiate a case with regards to that law. Okay. Additional weaknesses are the requirements for costs and time, obviously. So not everyone has the time or the money to initiate and pursue cases through the courts. Depending on cases coming before the court, expensive and time consuming. So exactly what we talked about. Now, another one, it's obviously really difficult to know when a judge may decide to distinguish a case. Now, distinguishing precedent refers to the fact where a judge comes in and says, I don't need to follow this precedent, this common law, because actually the circumstances of these cases, my case, and the one in which the initial precedent was established, the circumstances are different. So in that case, if they do that, and if they distinguish between those circumstances, the precedent doesn't apply to them, and they don't have to follow it, and they can make their own decision, even if they're a lower court than the court in which the initial precedent was established. So, it depends on the type of judge if they make an effort to distinguish and make their own decision. Because the judge could be a conservative judge, and if there is just a clear decision for them to follow, even if the circumstances are slightly different, they may just choose to follow that precedent and decide it's, those cases are similar enough, I'll just follow that decision. Now, judicial conservatism and activism. So these refer to different approaches being a judge. Conservatism relates to the idea that courts and judges should demonstrate caution when making decisions and rulings that could lead to significant law changes. So, conservative judges view lawmaking as strictly the role of parliament, and they prefer to avoid creating any new precedents or making any changes to common law. So they will be really cautious and really conservative. They try to keep the law stable and leave changes to lawmaking to parliament. Um, but this is obviously the positive thing, maintaining stability, ensuring parliament has the most power when it comes to making law. That's all completely fair. However, that means that there are some negatives with conservatism as well. So the weaknesses are that this restricts the ability of courts to consider social or political factors that can be very, very relevant when deciding the outcome of a case or a civil claim. It also means that these types of judges will very rarely try to distinguish precedent in order to be able to make a different ruling, and they'll just follow whatever precedent already exists. And they will not be proactive in changing the law or helping common law to develop further. Now, judicial activism is just the opposite. So, this relates to the idea that courts and judges should be considering a variety of factors when they interpret acts and deciding cases, that they should be helping common law and new precedents to develop. And whenever there is an opportunity for statutory interpretation, that they should take it and make the most of it. So, positives are that this allows judges to recognize the rights of people as well as even the community's views and consider that when passing judgments in order to make them more fair. And then the weaknesses, because they can really make drastic changes to common law and really drastic statutory interpretations, this may lead to more appeals, with people being unsatisfied with activist judges' court decisions. And it could lead to radical changes as well that don't sit well with the community. Radical changes to common law. Obviously, though, we don't want uh, court rulings and everything to be unfair and narrow and restricted. So judicial activism is the beneficial approach. And we said cost and standing are the two factors remaining that we need to discuss. So the cost of bringing a case to court obviously is very, very pricey, especially the higher in the court system we're looking at. So especially if someone wants to initiate a case to the high court, that is extremely expensive, extremely pricey. Such as, if their express rights have been breached by a law, many people, even if they have standing, will not have the time or the money to be able to pursue that. We know also that many people don't qualify for legal aid. It's only available to people in the lowest income brackets, and it's much less available for anyone in the civil justice system in comparison to criminal. So that's very problematic, and that can deter individuals as well. But this is really a big flaw, because courts can only make law on cases that come before them. Courts cannot develop precedent or complete statutory interpretation or interpretation of the Constitution if that case isn't coming to them in the first place as part of the dispute. However, there are still some strengths when it comes to the cost of bringing a case to court. One is that this can discourage frivolous claims. Now, if going to the courts was free or very, very cheap, imagine all the ridiculous things that people would go to court for and initiate cases for. We have backlogs of cases as it stands. Very, very bad backlogs. So, there is a reason that going to court is so expensive. And it's to help aid that and make sure that only people that really do need to go to court are going to court. So this helps to discourage any ridiculous claims. It also helps to encourage parties to use alternative methods or other institutions. So, using things like mediation, arbitration, and conciliation, accessing a tribunal in their state or area, or a another service that can help to the side that like Consumer Affairs Victoria. So this helps to again reduce the burden on the court system by using alternative methods. Now the weaknesses, litigants, so people who want to pursue their case or rights in court, may not be able to afford costs, even though they have standing and they're affected directly by a matter and their rights have been actually breached. They still might not be able to afford it. It can also deter parties from pursuing the appeals process because appeals are even more expensive. And we know that people do not have an automatic right to appeal. It might get rejected unless they have like a really, really sufficient grounds for an appeal. But you still have to pay for just trying to lodge that application. And then, of course, the requirement for standing, and we said that this is the requirement that the litigant has to be directly affected by the issues involved in the case in order for the court to be able to hear the case. So I can't go to court because someone did something to my friend or a law breached the rights of my friend. It has to be directly relating to me and affecting me. So strengths include that only cases can be brought to court by people who are generally affected by an issue that their rights have definitely breached in some kind of way. And it also encourages people not directly affected by an issue to seek other avenues of redress rather than in creating a burden upon the courts. So, such as starting petitions or demonstrations or talking about it on social media, basically just trying to get the government's attention or, you know, raise awareness so that someone with standing does go to court. But weaknesses, people who have a general interest in a case or activists or interest groups have no right to pursue a legal challenge on behalf of the greater good. And potential improvements to the law that could have been made by listening to those with only intellectual interest in the case are lost. I would really add here that laws that are unconstitutional or unlawful continue to operate unless that person with standing eventually comes along. So that's a really big weakness as well, that we might have unconstitutional laws just